Hi friends, welcome to I.A.S YouTube channel. In this video, we're going to learn important Supreme Court judgment of India. This information will help you in the competitive examinations such as UPSC or PCSC or any other competitive exams. Okay, let's see which are the very important cases and judgments given by the Supreme Court of India. The first case is Kesavananda Bharati versus State of Kerala. The case was held in 1973. The main theme of the case is propagating the basic structure of the Indian Constitution. The doctrine has a safeguard against the aspiration of the Constitution. This is the main theme of the case. In this case, particularly, the Parliament cannot amend or alter the fundamental structure of the Constitution. That is called basic structure. The basic theme or the basic aim of the Constitution, why they created, that should not be violated through the amendments. This amendment power has only Parliament. So the case was held that Parliament cannot amend or alter the fundamental structure. On the basis of this main obligation or ideology, the case was filed. The beside Kesavananda case was significant in the Supreme Court also preserve the integrity of the Indian Constitution. The functions of Indian Constitution rules and regulations or laws should not be violate or dangerous through the amendment. Then what is the main theme or basic structure? The basic structure formulated by the court represented in the pinnacle of judicial creativity and set a benchmark for other constitutional courts around the world. Through the Kesavananda Bharati case, the Supreme Court set a benchmark around the world, which who are now following the democratic constitutions. They all, for them, this Kesavananda Bharati cases, it's a benchmark case. The doctrine ruled that even a constitutional amendment could be invalidated whenever the constitutional amendment made by the parliament, that amendment, if fails to maintain the basic structure of the constitution, that time that amendment will be invalidated. The Kesavananda case was played a significant role, and it's given a path or benchmark to the world has the basic structure should not be violated through the amendments. In this case, we can evaluate what is basic structure of the constitution or what is the basic structure of the doctrine. Since the adoption of the Indian Constitution, the debates have started regarding the power of Parliament as well as when the amendments were proceeded or made, that provisions of the constitution, is it clear or correct? This debate is still going on. But in that case of the Bharati Nanda, the Supreme Court was given direct information or perfect judgment. That is, in the early year of the independence, the Supreme Court conceded absolute power of the Parliament in amending the Constitution. As it is, previously two verdicts were given by the Supreme Court, that is, Shankari Prasad case, it was held in 1951, and Sachin Singh case, it was held in 1965. Through this case, Supreme Court was given the power of the Parliament in amending the Constitution is correct. This means the Parliament had the power to amend any part of the Constitution and including fundamental rights. It was given these two cases. In the Golakananda case in 1967, the Supreme Court held that Parliament could not amend the fundamental rights, and this power would be only with the Constituent Assembly. Constituent Assembly was held in 1946 during the creating the Constitution or preparing the Constitution. Right. Those time the Parliament has the right to amend the fundamental rights. But after accepting the Constitution 1950, that Parliament could not have the right to amend the fundamental rights. This was nullified. So, in the 1967, Golakan and the case was held and given the verdict that the Parliament doesn't have the right or power to amend the fundamental rights. In future, if the Parliament amendment may change or making the differences between fundamental rights or any other laws, we can able to file the case against the government. The court held that an amendment under Article 368, the law within the meaning of Article 13 of the Constitution. So, the takeaway or abridges of the fundamental rights should be conferred by the Part 3. So, there is a perfect verdict was given by the Golakan and the case in 1967. The Parliament doesn't have any right to amend the fundamental rights. Through this case, in the Kesavananda Bharati case, the Supreme Court has verified Golakananda case and R.C. Copper case in 1970 and Madhavara Scindia case, it was held in 1970, and then government headed by Prime Minister Indra Gandhi had enacted major amendment to the constitution, particularly the Article 24, Article 25, Article 26 and Article 29. These particular articles were amended by the Prime Minister, then Prime Minister Indira Gandhi. So all the four amendments brought by the government were challenged in the Kesavananda Bharati case, and the Supreme Court given verdict that the government has the power to amend the Parliament has the power to amend the constitutions, but the Parliament doesn't have power to amend the fundamental rights. This is the Kesavananda Bharati case. As well as The government should not cross the basic structure of the constitution while amending the constitution. This is Kesavananda Bharati case. Now let's see next important case. This is next important case is Maneka Gandhi versus Union of India. It was held in 1978. The main theme of this case is expanding the meaning of right of life under the Constitution of India. The right to life is a personal liberty. Under Article 21, no person shall be deprived of his life or personal liberty except according to procedure established by the law. This is the Article 21 says. In the other words, the court were not allowed question any law or any matter how arbitrary or oppressive as violating the right to life or personal liberty. If the law had been suitably passed or enacted, the people or public interest litigation may file. By vesting in itself the power of substantive review under the Article 21, the court transformed itself from being merely of a superior or supervisor to being a watchdog of the Constitution. Who is watchdog? Here, Supreme Court is the watchdog of the Constitution. The Supreme Court judgment in the Maneka Gandhi case effectively meant that procedure established by the law under Article 21 would have the same effect as the expression due process of law. In a subsequent decision, the Supreme Court stated that Article 21 would read as no person shall be deprived of his life or personal liberty except according to fair, just, and reasonable procedure established by valid law. So, here, when Maneka Gandhi case was held in 1978, the Supreme Court stated that the personal liberty were given under Article 21, but it should not be cross the limit. Next important case is Mohammed Ahmed Khan versus Shah Bano Begum. It was held in 1985. The main theme of the case is questioning the sanctity of personal religious laws and bringing the debate on a uniform civil code to the forefront of the national discourse. At present, the current affairs or current scenario, the uniform civil code is debate is going on, and government also initiated to make a uniform civil code all over the country. So this case is important for the competitive examinations. The aspirant should note this case and read carefully. In April 1985, the Supreme Court delivered a judgment on the maintenance a divorced Muslim woman would be entitled to receive from her former husband in the case of Muhammad Ahmed Khan versus Shah Banu Begum. Okay, in this case, it is seen as one of the milestone in the Muslim women's fight for the rights in India and the battle against the set Muslim personal law. It laid the ground for thousands of women to make legitimate claims which they were not allowed before. Because at present, at present there is a talaq nullified, but before the talaq judgment, the many Muslim women were suffered just saying three times talaq. They were not given any maintenance for that woman, widower. Okay, so this case is very important. In the Supreme Court, upheld the right to alimony in the case. The judgment set off a political battle as well as a controversy about the extent to which court cannot interfere in Muslim personal law. Like that, the people was speaking, but Supreme Court were interfered and given judgment. The Muslim woman were has the right to ask what? To ask maintenance. So this at present, through this case in 1985, the Muslim women were get the maintenance for their life. The next case is Indra Sawhney versus Union of India. It was held in 1992. We were many times heard the Indra Sawhney case in other cases also. They were taken a Indra Sawhney case as a reference many times in many cases. The main theme of this case, Indra Sawhney versus Union of India case, is delivering the decision relating to the constitutionality of reservation under the Constitution of India. The reservation issue is going on till today. But in 1992, the Indra Sawhney case, the Supreme Court were given a benchmark judgment, that is 50% does not cross the reservation, but today we were crossed above 60% in many states. In the Indra Sawhney judgment, the court upheld the government's move and proclaimed that the advanced section among the OBCs, for example, Creamilia, must be excluded from the list of beneficiaries of reservation. It also held that concept of the creamy layer must be excluded for SCSs and STs. The Indra Sawhney verdict also held there would be reservation only in initial appointments and not for promotions. But the government, through this amendment, introduced Article 16, Clause 4A to the Constitution, empowering the state to make provisions for reservation in a matter of promotions to SC/ST employees if the state feels they are not adequately represented. This is political game, but Supreme Court also accepted this provisions. At present, there is a reservation for the promotion to the SC/SC candidates or employees in the state government employees. The Supreme Court was, as I started, was given quota at 50% for the reservation and capped, but till today no one state, many states are crossed this 50% reservation. Okay, the next case is Vishaka versus State of Rajasthan. It was held in 1997. The main theme of the case is innovating jurisprudence to prevent sexual harassment in the workplace. In the context of sexual harassment of women at workplace, judicial activism reached its pinnacle in Vishaka versus State of Rajasthan. The judgment was unprecedented for several reasons. The Supreme Court acknowledged and relied to great extent on international treaties that had not been transformed into municipal law. The Supreme Court provided the first authoritative definition for sexual harassments in India. The confronted with the statutory vacuum, it went creative and proposed a route of judicial legislations. Since there was no legislation in India related to harassment at the workplace, the court stated that it was free to rely on the Convention on the Elimination of All Forms of Discrimination against Women. The, for this convention signed by the India in 1980, it interpreting Articles 14, Article 15, Article 19 as well as Article 215 of the Indian Constitution. To justify its decision, the court referred to several sources, including the Beijing Statement of Principles of the Independence of the Judiciary, the Justice decision of the High Court of Australia, its own earlier decisions. The Supreme Court was set following guidelines because there was no law and rules and regulations for the women harassment in the workplace. The first point is the employer or other responsible people in the workplace are duty or bound to prevent or deter sexual harassment and set up a process to resolve, settle, or prosecute in such cases. This should be maintained by the employer or who is the responsible in that workplace. The next point is the first time in India defined authoritatively. The definition includes such as unwelcome sexually determined behavior, whether directly or by mistakenly, or implications such as physical contact, advances and demand, a request for favors, colored remarks, showing any other pornographies, and any other unwelcome physical, verbal, and non-verbal conduct is a sexual nature should be given punished. All employers or person in charge of workplace must strive to prevent sexual harassments, and if any actions amount to a specific offense under Indian Penal Code at present IPC section were changed by the Parliament. It was held in 19. So the Supreme Court was given Indian Penal Code as a reference. In 1860 or any other law, they must take appropriate action to punish the guilty. Even if the act is not considered a legal offense or breach of service rules, the employer should create appropriate mechanisms so that the complaint is addressed and redressed in the time bound manner. The next point is this complaint mechanism must, if necessary, provide a complaints committee, a special counselor, other support systems or services such as assuring confidentiality. The complaints committee should be headed by the woman, and at least half its members must be women. These suggestions were given by the Supreme Court. The employer must sensitize female employees to their rights and prominently notify the court's guidelines. Even if a third party is responsible for harassment, the employer must take all steps necessary to support the victim. The central and state government should adopt suitable measures to ensure the private sector employers implement the guidelines. These all the above guidelines and suggestions given by the Supreme Court to prevent the sexual harassment at workplace to the women. So this case also very important for your examination purpose. The next case is Aruna Ramachandra Shanbaug versus in Union of India. It was held in 2011. The main theme of the case is accepting passive euthanasia has been constitutional. Whenever the ill patient means patient is unconscious but still is taking the breath. The passive euthanasia is a condition where there is a withdrawal of medical treatment with the deliberate intention to hasten to death of a terminally ill patient. The Haruna Shanbaug case triggered a debate of euthanasia in India because a writ petition was filed under Article 32 before the Supreme Court of India was filed, asking for the legalization of euthanasia so that Aruna's continued suffering could be terminated by withdrawing medical support. In 2011, Supreme Court recognized passive euthanasia in this case by which it had permitted withdrawal of life-sustaining treatment from patients not in a position to make an informed decision. Subsequently, this case is a landmark judgment were given in 2018. The case was filed in 2011, but judgment was given in 2018. 7 years where Supreme Court was heard and finally in 2018 Supreme Court recognized passive euthanasia and living will. What is the living will? It's a living will is a concept where a patient can give consent that allow withdrawal of life support system. Whenever patient is coma stage means unconscious, the patient is cannot give any response or any authorities to their life. The life support system when what when it gives only to breathe, that medical system need to be withdrawal. It is a offense, it was offense. And after that in the Shanbaug case, the Supreme Court heard many things and verified many things, and finally it was accepted withdrawal of the medical support systems. That permanent vegetative state with no real chance of survival. When the patient doesn't have the survival chances, so that time, what may doctors say? So Supreme Court was held and given the judgment to withdrawal of the medical support systems. Finally, the patient may die. Next point is important cases Lily Thomas versus Union of India. The main theme of the case is struck down as unconstitutional section 8 class 4 of the Representative People Act RPA Act 1951 that allowed convicted lawmakers a 3-month period of filing appeals to the High Court to get a stay on the conviction and sentences. Section 8 of the Representative People Act 1951 deals with the disqualification on conviction for certain offences. A person convicted of any offence and sentenced in imprisonment for very varying terms under Section 8, Clause 1, Clause 2, and Clause 3 shall be disqualified from the date of conviction and shall continue to be disqualified for the further period of 6 years since his release. But Section 8, Clause 4 of the RPA Act gives protection to MPs and MLAs as they can continue in office even after conviction if an appeal is filed within 3 months. Okay. The Supreme Court held that charge treated the Member of Parliament and MLA on conviction of for offences will be immediately disqualified from the holding membership of the House without being given 3 months time of appeal as was the case before. The bench found it unconstitutional that convicted person could be disqualified from the contesting election but could continue to be member of the parliament and state legislatures once elected. Next case is Justice Case Puttaswamy versus Union of India. It was held in 2007. The Supreme Court ruled that fundamental right to privacy is intrinsic of life and liberty and thus comes under Article 21 of the Indian Constitution. Previously, we were discussed 2000 same Article 21 right to privacy, liberty. Same case again. Article 21 was claimed many times in the Supreme Court. 9 judges of this court assembled to determine whether privacy is a constitutionally protected value. The issue reaches out to the foundation of a constitutional culture based on the protection of human rights and enables this court to revisit the basic principles on which our constitution has been founded and their consequences for a way of life it seeks to protect. In this case, the Justice Puttaswamy versus Union of India case presents challenges for constitutional interpretation. If privacy is to be constructed as a protected constitutional value, or it would redefine in significant way of our concepts of liberty or entitlements that flow out of its protection. The Puttaswamy judgment of 2017 reaffirmed this right to privacy as a fundamental right in Indian jurisprudence. Since then, it has been used as an important precedent in many cases to emphasize upon the right to privacy as a fundamental right. To clarify the scope of the same, so the Supreme Court upheld the validity of the Aadhaar scheme on the ground that is did not violate the right to privacy of the citizen as a minimal biometric data was collected in the enrollment process as well as authentication process is not exposed to the internet. The case was given majority upheld in the constitutionality of the Aadhaar Act 2016, barring the few provisions on the disclosure of personal information, cognizance of offences, and use the Aadhaar ecosystem by private corporations. They relied on the fulfillment of the proportionality test as laid down in the Puttaswamy judgment. What is that proportionality test under Puttaswamy judgment? It held that privacy is a natural right that inheres in all natural persons and that right may be restricted only by state action that passes each of the three tests. That one, first, such state action must have a legislative mandate. Second one, it must be pursuing a legitimate state purpose. Third one, it must be proportionate, such as both in its nature and extent must be necessary in a democratic society, and the action how to be the least is intrusive of the available alternative to accomplish the ends. So, when it matter comes in the privacy matter, it is a right to privacy is a constitutional right to the human being or a citizen. The next case is Navtej Singh Johar versus Union of India. The main theme of this case is Section 377 of the Indian Penal Code. Navtej Singh Johar versus Union of India case. The Supreme Court unanimously held that Section 377 of the Indian Penal Code, which criminalized carnal intercourse against the order of nature, was unconstitutional so far as it criminalized consensual sexual conduct between adults of the same sex. The petition challenged Section 377 on the ground that it was vague and it violated the constitutional rights to privacy, freedom of expression, equality, human dignity, and protection from discrimination guaranteed under Article 14, Article 15, Article 19, and Article 21 of the Constitution. The court relied upon the judgment in the case of I.A.S. Puttaswamy versus Union of India, which held that denying the LGBT community its right to privacy on the ground that they form a minority of the population would be violative of their fundamental rights, and that sexual orientation forms an inherent part of self identity, and denying the same would be violative of the right to life. So, 377 is wrong. The Supreme Court given the verdict that 377 is nullified, and right to privacy or any person can choose the right to life as their sexual orientation. This all the very important cases and verdict were given by the Supreme Court of India, and in future we will discuss in many cases about this very important cases for the competitive examination. Thank you for watching. If you like this video, please like and share with your friends. Please click on the bell icon. You will get the notification of new videos, and subscribe my channel. Thank you. Have a nice day.